Okay? Um, and lots of people ask them, why should someone take this law seriously? India is very good at passing laws, right? So that's one. Secondly, there's also a lot of confusion between privacy as a culture and data privacy as a concept. So I'm going to take a step back and talk about that. So privacy as a culture is, where, as people say, we as a country are, or rather whole of Asia culturally, we'll tell our life story to the person, stranger next to us on the bus or the train, right? But and that is going to continue for the next 10 generations. But data privacy is something else. Today we are the single largest digital nation in the world, right? And digital India is galloping, and 1.4 billion people, our data is more.
I would not, make our guests wait more. So, would request if you can begin with your presentation, and I would request our guests as well to post in questions as many as we can. After the session, we will address those, and those which are detailed needs deep diving, we will connect one to one. Over to you, ma'am.
Yeah, let me just share my. Okay. So I thought I'll, talk about the challenges of implementation. I think there's enough data out there about what the law is about and all of that. So before that, just a quick overview of the essentials of the India Digital Personal Data Protection Act, so that we are all on the same page. Okay. So first and foremost, and this is stripped of all legalese, and we have a primer out, so I can share that as well. Um, for any personal data that the organization processes, you need to have a clear purpose for processing, like what are you actually doing with that data, right? Now that purpose, you need to get consent from the data principal, which is the individual, for each purpose. So if you're collecting my data and using it for, let's say, giving me a bank account, and you're also using it to send me direct mailers, they're two different purposes. Okay. And so each purpose you need to get consent. There are a few alternatives to consent, like, for employee purposes, all that. I'm not getting into that, but essentially consent is the bedrock in India. Then you have to make sure that you use the data only for those purposes and not beyond. Okay. Collect whatever is needed only for those purposes. So don't ask me for 50 data points when all you need is 20 data points to service me. For the rest, you give a choice. So if somebody is willing to give it, but you can't compel people to give data. Another aspect is you need to delete the data after the purpose has been served. Okay. Unless, of course, other laws require you, like for example, employee data is required to be retained by other laws, or banking laws require you to retain some certain data, etc. Or you need to delete data once the user withdraws consent. Okay. So this is the high level essence of the law. Secondly, for any personal data that you process, you have to implement security safeguards so that there are no data breaches. If the data is breached, you need to report this to the regulator, which is the data protection board that is being set up, and the individual, the data principal who is affected. Then you need to also set up grievance redressal mechanisms. Um, in addition, certain organizations are going to be categorized as something called significant data fiduciaries. So all organizations are called data fiduciaries, and I'll come to the terminology in a bit. But some organizations who are considered high risk will be categorized as significant data fiduciaries. What they need to do, addition to all that we just discussed, is they have to appoint a data protection officer who needs to report directly to the board or senior management. They need to carry out something called data audits, which is very new, for which they have to appoint a data auditor, and they have to conduct something called data protection impact assessments and other measures. So all this will come out slowly in terms of what they need to be doing. So typically people who process a large volume of personal data, or they process very high risk personal data, like if it is health data, medical data, children's data, all these guys are going to come under the significant data fiduciary category. Okay. There's a special call out for children's data. So if you are processing children's data, you need to get verifiable consent from the parent guardian. And the second point is very important. You cannot track or do behavioral monitoring of children, okay, online especially, and you cannot do targeted advertising to children online, okay. And anything else, they put this blanket clause which says that anything that can be cause any detrimental effect to the well-being of the child. There are also, I was talking about the rights, right? So there are four rights given to people like you and me, individuals, okay? One is right to access information about the personal data, which means if I invoke this right and go to an organization, I need to know what personal data about me is being processed, what are the processing activities undertaken, meaning what are you doing with that data, identities of other organizations with whom data is being shared, and description of the personal data being shared with other organizations. So that's a very powerful right. Second powerful right is right to correction and erasure, which means I can ask to correct data, I can ask to erase all my data lying with any organization. Then you have the right to grievance redressal, which means that you have any grievances about privacy, you can, get them addressed. And right to nominate data, which means like you have nomination in other aspects that are there. If you're transferring data outside India, luckily, this is very open. The government is going to just blacklist certain countries, but otherwise you can transfer. And this was under a lot of debate and discussion. Of course, individual regulators can put curbs. For example, RBI says you cannot transfer payment data outside India. So that will continue, but at the overall law level, they've not put too much of the thing. Governance of the act will be done by the Data Protection Board. And the key penalties that we talked about, right? So up to 250 crores if reasonable security safeguards are not installed to prevent breaches, up to 200 crores if you don't give notice, like if you don't inform the board or the individual about breaches, or if you don't meet the additional obligations towards children, in up to 150 crores if you don't meet any of the other obligations for a significant data fiduciary, and up to 50 crores for breach of any of the other provisions of the act. So this is one of the reasons why people are taking this seriously. Who is it applicable to? It is applicable to any digital data that's processed in India, or if data is being processed outside India but is targeting Indian, people residing in India. So it is not about citizenship, it is not about residency. It is like if the transaction is taking place involving personal data on Indian soil, that comes under the purview of the Act. Okay, because there's a lot of misinformation floating, so I just thought I should talk about this. And this is very similar to all other privacy laws. GDPR is also exactly like this, so is everybody else. What really is personal data? It is data in digital form as well as non-digital form, but which is digitized subsequently. So, for example, if you're collecting information on a paper-based form and you're subsequently scanning it and digitizing it, then from that scanned version onwards comes under the purview of the law. Okay. um, a big question is what really constitutes personal data, because many of us intuitively, when we say personal data, we think of, okay, identity data, like, my name, address, let's say passport number, Aadhaar number, etc., or financial data, health data, or even stuff like beliefs, religious, political, etc. All of this is personal data, which we at Arca call above the surface personal data. However, the definition of personal data today is far beyond that, and it is expanded to cover a whole lot of data, which is what we call below the surface. Data that comes out of mobile app permissions, right? Contacts, location, etc. To data that comes from cookies and trackers on websites, data that comes out of sensors, RFID tags, from smart devices, health assistants, let's say your smart TVs, etc. That comes out of derived inferred data via analytics, from even stuff like smart vehicles. Like one of our auto clients was getting into the EV space. We discovered so much of personal data from that vehicle, which comes under the purview of privacy laws, not just India, but outside as well, right? So, a lot of this is personal data, which most people intuitively don't realize. And all of that is comes under the purview of privacy law, not just India's, any privacy law globally. Okay. The other question is, when you say processing, what does it comprise? It comprises everything from collection right up to destruction, including wherever you're sharing data, disclosing data, like whether manually, automated, include
and stuff like that.
Yeah,
Whatever data I am uploading there, I mean, knowingly I am uploading my PAN card, Aadhaar card, and stuff like that. Unknowingly, I am also uploading my location, where I visit, what all calls I have made, who are in my. Then this data goes to another company, which is not the bank, because bank has outsourced to say ABC vendor who is man. So in that case, what I mean, bank can say that okay, I'm not, or a school can say I'm not responsible because this person is handling it, and I have an NDA in place and stuff like that. So how do we?
bank continues to be accountable for it.
Okay.
They will then have to, have very tight clauses and, agreements with their vendors to make sure they don't violate the law. But the bank or the school remains accountable end to end. They can't say I've outsourced it and therefore it's not my problem.
And if as an individual, if I want to know that okay, my I want to understand from my daughter's school that what all data, then I can question the school or the bank that what all data you are having, delete all non-relevant stuff and stuff like that.
Absolutely. Absolutely. So if I were to flip it, okay, because we've been working with ITITS companies and KPOs for a while now, if you look at the kind of agreements they sign with their clients, right, they have all this in their agreements. It says that I will ask you for data of deletion and you have to ensure that the turnaround happens in so many days, or it says that I will ask you for this, because they are in turn accountable to their data subjects, right, or data principals. So they pass this down to their vendors. Similarly, banks or schools in India will have to have watertight agreements to ensure that their vendors do this. So, for example, if the law will downstream rules will come out and say that a data breach needs to be reported in X number of hours. Typically, worldwide, it is usually 72 hours. Most laws say allow for 72 hours. So the downstream agreement typically says that if there is a breach at your end, you have to report it in 36 hours. We've seen that. So why does it say 36 hours? So that an additional 36 hours is available to the main, organization, let's say the bank or the school, to digest that information and further report it, right? So this kind of intricacies will come up now for us.
One very logical. Every time I download an app or I'm trying to use an app, there is a blanket I agree and understanding clause which I have to take.
Yeah, that will need
Does
to go.
this does this does our DPDPA law supersedes above it, or and maybe if a breach happens and the company or organization is unable to take whatever steps are necessary, then that agreement will be above it, or the DPDPA makes it mandatory even if I have signed some agreement and.
Yeah. The if you sign an agreement, which is what is called a blanket, okay, right? Which is like saying I'm consenting to a what is called a clubbed bunch of statements, right? So first of all, that's not allowed. And if they're still going ahead with it, then it's null and void. That agreement doesn't hold because you're trying to do something which is violating the law in the first place, right? So you cannot go ahead with that kind of an agreement. So you will see changes to it.
Okay, that's assuring, ma'am.
Yeah, let's hope so. So there are, there's a time frame allowed for organizations. So at the center is the data principle, that is you and I as individuals, about whom this whole discussion is about. The organization that collects and basically, who's accountable to you is the data fiduciary. They are essentially the organization that decides why, which is called the purpose. Why is the data required and how it is going to be processed? Okay. Then they can outsource it to processors. Processors can be outsourced. There is maybe some processors will also collect data on behalf of the fiduciary, but they're processors. Then you have, as I said, certain organizations will be classified as significant data fiduciaries. They have additional obligations like appointing a data auditor, appointing a data protection officer, and so on. Let's see why. Okay, conceptually, every law, including the DPDPA, has a certain set of privacy principles embedded in it. Okay, and they're uniform. They may use different terminology, but they're uniform across laws. And one of those principles is security safeguards. That is, that you have to secure the data that's lying with you. Okay. However, when implementing these in an organization, a different set of challenges crop up. Okay. So if you look at an organization data, right, you have a whole set of data, some of which is non-personal, some of which is personal, right? So personal data is always a subset of organizational data. In some types of organization, let's say financial sector or healthcare and so on, the personal data subset is very large, right? Because a lot of it is personal data. But in some organizations like manufacturing, etc., the personal data subset is small. Okay. Now, therefore it's a subset. Now, when you implement security in your organization, you implement security for all data, right? Whether it's personal, whether it's non-personal. And therefore, those measures get applied to everything. Whereas in a privacy program, whatever you implement is implemented only for personal data in an organization. So another view is, if you look at it from a risks perspective, okay, traditionally your security programs are designed to solve for what we call three risks, right? So risk to confidentiality, integrity, and availability of data. Whereas for risks that are pertaining to inappropriate collection, inappropriate or wrong usage of data, inappropriate disclosure, location, etc., for personal data is not addressed by your security program, and for which you require a privacy program. Another reality is that program to meet the requirements, one of the biggest ones is breach notification, which means that if you have a breach, you have to detect and notify, right? Most organizations are not doing it except in certain buckets. Second, you initiate a privacy program grounds up. The overlap is security of personal data, which you continue keeping in your security program because you're anyway looking at security of all data, right? One note, and this again keeps coming up, is that the same team can continue running both programs. Like maybe the same CISO will have both under them, or the same CIO will have both under them. So do not confuse the same team, or one individual or one team running both programs with mixing the two. They're wearing dual hats and they're in charge of both programs. Okay. Secondly, why do you need, you need frameworks to implement, right? So those of us in security are used to seeing frameworks like ISO 27001, etc., right? Similarly for privacy. And why do you need it? Because you may have exposure to one law, or law plus regulation plus mandate. Like if you're in a NBFC or a bank, you have exposure to RBI's cybersecurity mandate. You may have something else that is coming up, and over a period of time you may have exposure to multiple laws, right? So currently something may be applicable, something else may be applicable in future. Secondly, existing laws also keep adding, right? New rules keep coming up. If you look at the GDPR, it was passed in 2016, became applicable in 2018. Even today in 2023, we are seeing guidances come out, right? So this is going to go on for a while. Doesn't mean that, and you can't keep going back to the drawing board every time, right? So if you see across everything, there are certain constants. They are from an organization's perspective, that all of these have privacy principles, rights, and organizational obligations embedded in them, which is what needs to be translated to policies, processes, technology controls, people training, orientation, etc., for which you need frameworks. So, in other words, all of this needs to be configured into frameworks so that what you have implemented is robust, is scalable, is agnostic of the law, and is stable. Okay. So, that is another thing I wanted to highlight.
So, ma'am,
Therefore, how do you?
if we have to put it in one line, the framework should be flexible enough so that the changes, because the data dynamics of the laws and changes as and when things come up.
Absolutely, bang on. You said it. Yeah.
Yeah.
Okay. So now getting into the actual approach and methodology, and this, because as I said, we've spent almost the last decade implementing privacy across multiple laws, across 100 plus engagements today, right from, as I said, 5 people companies to 250,000 people strong companies. This is something that we have seen that works, okay, and which is what we implement and follow. One is start small, okay. Do it like, have a privacy product pilot. If yours is a medium or large enterprise, pick one vertical, one business line or process or product or geography, whatever is applicable, and do that. If you're a small company, pick your core business to start off with and make this the scope, because you don't know what you're getting into. This is a new animal for everybody in the organization. This is something, therefore start small, okay, experiment with that. Adopt a approach which is, you lay the foundation, which is, and I'll get into this in detail. Understand what personal data you're dealing with. Most organizations have no view of what personal data they're dealing with, okay. How is it flowing between applications across geographical boundaries, with and to and from third parties and so on, okay. And what is it being used for? So while it may not be documented, there is an intuitive understanding of what data is supposed to be used for, right? So document that. Now once you build this map, your foundation is ready. Use this information to move to the next stage, which we call design. Now sometimes you may want to do a formal gap assessment. You do a gap assessment, but actually otherwise just jump in and start implementing your program, right? So first, design an internal privacy policy to guide the organization. Design the privacy notice that goes on your website or your app or other points of collection that you may have. And this is the framework which I've just taken instances from our own framework that we use, but you can use any other framework. It most to make offers to your employees, then that you have to get consent of employees, okay. So you have to build this matrix of all the purposes that you're using for processing. Design a, if consent is a big thing, then design a consent life cycle process, right? What do you take consent for? What are the linkages at the back end, audit trails that you need to maintain? So if you're taking consent for 5 different purposes and each of them is linked to maybe, different applications or processes manually at the back end, every time that consent changes, like as an individual I can go and withdraw, right? If I withdraw consent and say from tomorrow I don't want to get direct mailers for product A, but I'm okay to get direct mailers for product B, then at the back end I need to be able to map it, and the correct things need to be passed on, right? Rights requests, we just said, right? Anybody can raise a request, so you have to have a front end to accept that. You have to set up back end processes right from authenticating, because a lot of fraud is also happening from this. So is it a genuine request? Is it really Umesh asking, or is it Shivangi pretending to be Umesh and getting data, right? Right down to actually being able to cater to that, right? Uh, Therefore, then set up a third party management process, right? Right from due diligence to perform PDAM for every third party. Yeah.
If there is a breach when I go home, suppose I'm on Google, I'm assessing my personally. If there is a breach, I
Yeah.
don't come to know. Organization does not come to know. How does an organization then manage, that kind of fear? So every device has to be monitored, mapped, and
Yeah. Yeah. So the base assumption is not that the data is lying in databases. Okay. In fact, the structured data, as you know from your security experience, structured data is easier to protect. It is the unstructured data lying on people's devices, data lying with, as you said, right, on your hand phones, on your mobile phones, on some devices, all of them need to be mapped, and you need to figure out ways to detect and protect. And most breaches happen at these places,
Yeah.
not at the core, right? So yes, that's why I said, no, it takes so long to.
Yes, yes. There are, I mean, it is not. There are a number of kind of tributaries in a river which we have to plug in every point, and that makes it, I believe, a Herculean task. I guess. Circumstances you can tell where companies and the DPDPA Act is not applicable.
Actually, I don't see anybody, because, as I said, if you're an organization and you have employees, for those employees, you always will have personal data, and for that, you will always have to, for that, you will come under the purview of that. So, I don't think there is any organization for whom the act is.
The time again, ma'am, and look forward to hear from you again.
My pleasure. Thank you for inviting me again.
Thank you, ma'am. And I'll share the details of the presentation and the slides to all the registered participants in a mail. And should you have any details,